like to welcome everybody to the latest Digit debates from the Digital Futures at Work Research Centre. The debate started last autumn, and this is the fifth and penultimate debate in the spring series. And the presentations and summaries of previous ones are on the Digit website. And as a member of the Digit Advisory Board, I'd also like to thank the Economic and Social Research Council for funding Digit. Our speakers today are Robin Allen QC and Dee Masters. Robin and Dee are practicing barristers. They're both based at the Cloisters Chambers in London, and they specialise in equality and human rights law. They set up the AI Law Consultancy in 2018 to provide an ethical and clear regulatory framework for artificial intelligence systems. And the AI Law Hub that they set up and maintain provides an invaluable source of information on AI, equality and data protection, both in the UK and Europe. In my previous role at the Equality and Human Rights Commission, I was part of a team which reviewed the literature on algorithms, AI and machine learning in recruitment. We benefited hugely in that work from Dee's and Robin's expertise, knowledge and support for the project. And we drew on several of their publications, including a major 2020 report regulating AI, which was prepared for Equinet, the European Network of Equality Bodies. And I've seen that Gemma's put a link in the chat to that particular report, which I'd strongly recommend. I'm therefore really looking forward to their presentation, which has a very intriguing title, What to Do, Almost Everything About Us is Happening Without Us. They'll speak for about 30 minutes, and then as Gemma has already outlined, there'll be an opportunity for questions for around 15 to 20 minutes, and we will finish at 2 o'clock. So I know, Robin, you're going first, so over to you. Thank you.
Dave, thank you very much. Can you just give me the thumbs up if you can hear me? Yep, that's great. Okay, well, hello all. Thanks so much to Digital Futures at Work for this invitation to talk. In January 2016, Klaus Schwab, the founder and executive chairman of the World Economic Forum, declared that the world was entering the fourth industrial revolution. He said, "We stand on the brink of a technological revolution that will fundamentally alter the way we live, the way we work and relate to one another. In its scale, scope and complexity, the transformation will be unlike anything humankind has experienced before." He was talking about the impact of the accelerating increase in computing power and was seeking to alert the world to its capacity to analyze and use data so as to make and execute decisions about and for us. His concern was the effect that this could have on every aspect of our lives if it were to be uncontrolled. His aim was to highlight the absolute necessity that humans should be in charge of this process and not merely victims. So here he is, and here's his book. And this is how he concluded. It all comes down to people and values. We need to shape a future that works for all by putting people first and empowering them. In its most pessimistic, dehumanized form, the fourth industrial revolution may indeed have the potential to robotize humanity and to deprive us of our heart and soul. But as a complement to the best parts of human nature, creativity, empathy, stewardship, it can also lift humanity into a new collective moral consciousness and based on a shared sense of destiny. It's incumbent on us all to make sure the latter prevails. Well, his warning was apt then, 2016. 5 years later, it is even more so. And we must ask the question, has his warning been heeded? Well, by September 2020, across the EU 27, Norway, Iceland, and the UK, over 40% of enterprises have adopted at least one AI-powered technology. 25% have adopted at least two. 18% have plans to adopt AI in the next 2 years. So there's much talk about the challenges, and there is indeed a growing understanding of the need for better regulation. But at present, there has been no new legislation. Well, there's been much talk about the technologies, and indeed the digital futures is part of that discussion. And there's a growing realization within some bodies which advise the UK government that specific regulation will be needed soon. Why does this matter? Over to you, Dee.
Thanks, Robin. Well, one of the reasons that this matters is that when it comes to artificial intelligence and automated decision-making, there is a very significant impact on the employee-employer relationship. Now, last summer, the TUC launched the first ever survey into the worker experience of these new technologies. The report which followed, you can see on the screen, Technology Managing People, the Worker Experience. And it really is essential reading. What it explains is that these new forms of technology are now in existence in the UK at every stage of the employment relationship. So from recruitment, through to monitoring, through to the management of people, and indeed all the way through to dismissal. But what this report also tells us is that despite the growth of these technologies, often employees and workers don't know that this technology is being used, and that managers often don't understand how it works. That's partly because of the black box, but that's also because these technologies are often bought in by third parties rather than being created by the employers themselves. Now, when Robin and I first digested that report, what really came to mind was this slogan from the disability movement from the 1990s, "Nothing about us without us." And you'll probably remember that what that slogan was intended to do was to evoke the idea that disabled people shouldn't be subject to policies, they shouldn't be subject to processes where they also didn't have a seat at the table. And it occurred to us that this slogan, "Nothing about us without us," very much has a contemporary resonance. We have this situation in which employers are using technology that have significant impacts on employees and workers, and yet they're not part of the decision making. Sometimes they don't even know that it's happening. Now, what the TUC asked us to do was to look at the legal implications of this growth of AI and ADM. And Robin and I concluded very quickly that if we weren't careful, we'd be entering a new era where almost everything about us is happening without us. Now, in today's session, what we want to do is talk you through some of the potential incompatibilities between the modern employment relationship and the use of AI and ADM. And we should be clear that we'll be publishing a report, or the TUC will be publishing our legal opinion at the end of this month, hopefully before Easter, in which we're going to make really detailed recommendations around these topics. So really the purpose of today's session is to whet your appetite, as it were, before the more detailed report comes out later in the month. Now, at this point in the talk, I was supposed to talk you through some of the basic concepts, but having seen the attendance list, I think Robin and I concluded that you didn't need that. So we're going to fast forward instead to the next slide, which is what uses of AI and ADM do we need to think through carefully when it comes to the employment relationship? And it seemed to us that there are really 6 points that are absolutely key here. First of all, we need to be thinking through those uses of technology which risk introducing bias, those uses of technology which risk invading privacy in the workplace, and that's even more important in this post-pandemic world where people are increasingly working from home. We need to be thinking carefully about technology which could lead to irrational or unfair decision-making about employees and workers. We also need to think through issues of observability, by which we mean, do workers and employees know that this technology is being used? But equally, if they do know, is it transparent? Do they know what data is being used about them, how it's being used, and how that data processing is impacting on them? We also realised as part of writing our report that another consequence of using AI and ADM in the workplace is that the role of human management was becoming eroded. People were increasingly becoming managed by algorithm and by platform. And equally, this new technology complemented and encouraged what's being referred to as the always on culture. So these are the headline points that Robin and I are going to talk you through before linking it to the modern employment relationship. So let's think about bias first of all. We're all very familiar, I'm sure, with the idea that human beings can be biased because they can be misled by stereotypes. So rather than making decisions about the person that's in front of them, they make a decision about the stereotype that's associated with their protected characteristic. And that leads to bias, it leads to discrimination. Sadly, technology can do exactly the same thing. And one of the examples that you'll often see referred to is a US example. It's from the criminal justice system. It's a system called Compass. Now, Compass is a system that's used in some states to assist judges make decisions about sentencing. And the idea is that the algorithm will tell the judge what the risk of a particular offender has of reoffending. That information can then be used as part of the sentencing decision-making process. A group of journalists and researchers from an organisation called ProPublica decided to look more into the Compass system. They decided to compare the predictions that the algorithm made as against the actual real life outcome. And what they discovered was that when it came to Black offenders, the algorithm was twice as likely to incorrectly predict that the offenders were going to commit a crime in the future versus white offenders. And what the researchers concluded was that far from the Compass algorithm providing objective information to the judge, what it was doing was simply replicating historic prejudice, historic discrimination, historic, if you like, stereotypes. And when it comes to the employment relationship, that type of bias also exists. And one piece of research that we'll talk about in our TEC report is this. Researchers discovered that across 191 different countries, a gender-neutral job advert in a STEM field, so that's a science or engineering role, was significantly more likely to be shown to men than women on a social media platform. So in other words, before the employment relationship had even begun, women were facing a barrier because they weren't even able to understand that the job vacancy existed in the first place. And indeed, other research has demonstrated that women are less likely to be shown adverts for high-paying roles in general on social media platforms because of the way in which algorithms work, because of the way in which they embed discrimination rather than necessarily act in an impartial or objective way. We also discovered through our research that there are also huge privacy implications to AI and ADM in the workplace. And one particular statistic that really stood out for us comes from the TUC survey. The TUC found that 27% of workers had had their communication screened, 13% had experienced desktop monitoring, and 8% were aware of social media screening. And a lot of this can be highly intrusive. So we know, for example, that there's technology in existence which looks at how often the keyboard is interacted with. Are people typing fast enough? Are they working? And we know that there is tech which allows webcams to take time-stamped images of people at their desks so that line managers can make a decision. Is this person working hard enough? Is this person working right now? Are they taking too long when it comes to their break? Robin, over to you.
Thank you, Dee. Well, on to one of the next uses that we are particularly concerned about, irrational or unfair decisions. And we've come across this in our own work on a number of occasions, because AI-powered technologies are also being used to drive important decisions. For example, who should be made redundant, or whether undesirable behavior has occurred, or issues such as whether somebody should be disciplined for absence. The technology is not perfect and not beyond criticism. Ordinarily, a worker or employee can ask questions or seek to challenge a human-made decision so as to understand what is rational and what is fair. But when AI or ADM is used, this may be much harder. We are representing 3 women at the moment who were dismissed from long-term relationships with their employer during the pandemic. And they were dismissed as a result of an AI-powered assessment process in which an algorithm and not a human decided whether they should be made redundant or not. Disclosure has shown that many thousands of data points were analysed, and yet no human manager can tell our clients why these points were chosen and used, what they mean. All they can say is the outtake from that was a basis on which they were chosen for redundancy. So there's no reassurance that the decisions were not trained by any protected characteristics or proxies for protected characteristics. And there's an even wider problem about knowing what exactly is going on. Now, we've already said a bit about observability and transparency. And I want to just echo this point about observability that Dee mentioned. It's a word we think you're going to hear a lot more about. As we went through our report, it became clear to us that we needed to say a lot more about this because people are not realizing what is actually happening to them. If we start at the beginning of the work, we know, as we've seen in the STEM case, that AI systems are being used in the workspace in which employees cannot even observe. This starts at the point of selection for candidates. It's taking place by ADM systems scraping the internet for CVs and then rejecting many of them before finding a shortlist. And we also have this problem of transparency, which in a sense has been a theme in some of the other points that we've already made, in which people simply don't know how the system has actually operated. So let's move on to the next use, this point about actually having human management. This photograph of likely looking faces were the House impeachment team that managed the process that ex-President Trump went through. He knew exactly who was managing the process that was going to interfere with or not his future career prospects. But who's managing you? Man, woman, or machine? There are examples on the AI Law Hub of cases where we've seen that actually it's the machine that does it and that the human intervention is simply not there. If you're interested in looking at this, check out our blog on Deliveroo. There's an interesting case which was heard in the Labour Court in Italy, in which effectively the Deliveroo allocation of jobs was being done by a machine, making terrible decisions. Have a look, check it out. So on to the next point, always on. We've become increasingly concerned about this. And in a way, us in the United Kingdom are really quite slow to the party on this. Legislation is already on foot in some European countries to protect people from this sense that you always need to be on your mobile phone or on your computer, and that you can be reached at any point, and that your productivity is being measured literally all way through 24 hours. This is something which is highly stressful for many people, and increasingly so, we think, during the pandemic. So over to you, Dee, to talk about how we've approached this.
Thank you, Robin. So as I said at the beginning, after the TEC had put their survey reports together, they asked us to think through some of the legal implications for the modern employment relationship. And we came across the following key issues: equality rules, mutuality of the employment relationship, trust and confidence, statutory rights to a fair process, health and safety, and of course, data protection and privacy issues. So going through these one by one, dealing first of all with equality. Just wait for the slide to change.
It just goes to the end, Dee, so.
Oh, all right, okay. We won't be doing that then. So equality. So what we have in the UK is the Equality Act. The Equality Act dictates what can happen in the employment relationship, both at the recruitment stage and once an individual has become either an employee or a worker. It can even apply sometimes after the employment relationship has ended. And clearly, some of the uses of AI and ADM that we've discovered potentially infringe the Equality Act. Moving on to the obligation of mutuality, this is something which employment lawyers are very familiar with. So the bedrock of the employment relationship, which you don't see in any other contract, or at least not in all contracts, is this idea, this bargain: I'll do something for you if you do something for me. And the basis of that relationship to date has been on the notion of human interaction, a human relationship. And we query, and it's something we'll be exploring further in our legal opinion, the extent to which imposing technology on that relationship can really be compatible with that type of employment relationship. Trust and confidence, it is another central plank to the employment relationship. So this is an implied term in all contracts of employment. And what it requires is for the employer to be able to explain decisions that it makes about employees. It also requires decisions to be made in a lawful and rational way and driven by considerations of good faith. And again, that leads to really profound questions. If you are using an AI system or an ADM system to make decisions about employees, decisions that people might not know about because they're not observable, or that they don't understand because there's a lack of transparency and the problem of the black box, is that consistent with the implied term of trust and confidence? Is it compatible with the modern employment relationship? What about the statutory rights to fairness? So again, when it comes to decisions around dismissal, provided an employee has 2 years continuous service, they have a statutory right that decisions should be made fairly, which applies both to the process that's followed, but also the outcome. Now, if people are being chosen for dismissal by an algorithm using data points that nobody understands on the basis of a decision that can't be explained, how can that be compatible with the statutory obligation to ensure that dismissals are fair? Health and safety. There is a wealth of health and safety statute out there that protects all aspects of the working relationship. But one of the points that we talk about in the TUC report is whether that is fit for purpose, where we know that there are different threats to health and safety in this new always on world. And then finally, data protection and privacy. We have the GDPR, the UK GDPR now. We have the Data Protection Act. It's not often talked about, but the freedom to have one's personal data processed in a way that you understand is a basic right. It's a human right. And how far is this being respected when it comes to the employment relationship? And so what we seek to do in the report, in the TUC report that will be published later in the month, is really think through these key aspects of the employment relationship and examine the extent to which they can be compatible with this new use of technology that, as Robin explained at the beginning, is increasing more and more. Robin, over to you to conclude.
Well, thank you, Dee. We're looking forward to having a good discussion with you, and we hope that we've provoked some thoughts at your end. But in a sort of summary conclusion at this stage, we believe that to ensure that the most important legal protections which we've been talking about continue to govern effectively the employment relationship, a debate is needed about red lines. Are there some things which simply must not be allowed to happen? We ask the question, to what extent can and should AI and ADM be used in work? What are these red lines which must never be crossed? And what legal reforms are required in order to support them? And that's all in the context of asking the question, is the Labour Code, that's the full range of statutory provisions grafted onto the common law, fit for purpose? Our report for the TUC will be published shortly, and it seeks to answer these questions in great detail and to start a thorough debate about these important issues. What we hope we've done today is to start you on a journey we've been on to get you to think through these important issues, which we believe will come to dominate Labour policy decisions and also litigation. Thank you for listening to us, and let's start the debate.
Thank you very much, Dee and Robin. That was absolutely fascinating and thought-provoking presentation. I'm sure there'll be lots of questions coming your way, and we'll all be looking out for the forthcoming TUC report, which is clearly going to be making a really important contribution to the discussion. So First of all, could I invite everybody, if they'd like to do so, to put their cameras on? And then just to remind you, in terms of asking questions, either put them in the chat or yellow the hand function. And I can see we've got a question already. And when you ask your question, could you briefly say who you are, where you're from, then ask your question? So I think the first one we have is from ESme Terry. ESme.
Hi there, my name's ESme Terry. I'm a research fellow at the University of Leeds and attached to Digit. Thank you for a really fascinating presentation. It's great to get a legal perspective on what are issues that a lot of us at Digit are looking at on a daily basis. And my question is about right to disconnect legislation. You mentioned briefly about legislation introduced in Europe, and some work that I'm currently working on is analysing the impact of the French right to disconnect legislation. And one of the issues with the French rule is that actually it doesn't draw a red line. So all that it necessitates is a conversation between the employer and employee representatives about workers' right to disconnect. It doesn't legislate an appropriate number of hours. It doesn't draw a roof on what is and isn't acceptable. So that red line's really missing. And there are similar issues in other European policy on this. And I just wanted to ask you what your thoughts are on the potential introduction of a right to disconnect or something along those lines in the UK, and what that might look like, and any recommendations that you would make as legal experts to make that sort of legislation effective in moderating the employment relationship.
Dee, do you want to go first?
Yes, I will. So there's always an appeal, I think, especially when you come from a legal background, to have nice, clear lines and rules that apply universally. But I think where Robin and I got to is that you can recognise a right to disconnect without having to be massively prescriptive, because so much will be dependent, we think, on the industry, the sector, the reality of the particular role. And something that we were very struck by, especially working alongside the AI working group within the TUC, is how really the first step towards recognising a right to disconnect is making sure that trade unions and employee representatives are at the table. That these decisions about what's appropriate and not appropriate in terms of working time shouldn't be simply imposed from the top. It's got to be a discussion. It's got to be employee and worker led. So I think we favour an approach that can be individualised and personalised in that way. But that's not to say that an employer simply decides. It's got to be a two-way process, and there's got to be proper consultation with the people who are affected so that it can be a meaningful right rather than one that can simply be caricatured as being over onerous or creating too much red tape for employers. Yeah, Robin, I don't know if you want to add to that.
Well, just very shortly. I mean, I've been involved in this discussion in the context, and indeed Dee has to some extent too, in the context of lawyers. I mean, it used to be a game amongst lawyers to send an email at about 10 o'clock on a Friday to ruin your opponent's weekend, and then to make it look as if they didn't work, that if they didn't deal with it over the weekend. And I'm very glad to say the judges have begun to realise that this is a bit of a problem, particularly the family law judges, not so much the commercial judges. And when we started looking at how this could be developed amongst lawyers, the first thing that happened was to try and discuss a protocol for the profession, which addressed the specificities of the profession, the need to deal with emergencies, which do arise, but also a recognition that there was a basic norm that people needed time away and so on. So the first thing is, let's get this discussion really going, because I think there does have to be a recognition that the particular context will need sometimes particular rules. But the basic principle that people must be separated from their work for a period of time is so important, and that must be one which has some non-negotiable core.
Great, thanks, Dee and Robin. The next question, which is, I think, broadly related to the first one, about is the role of trade unions, and that's from Horan Voskeritsian. Apologies if I've mispronounced that. Horan, would you like to ask your question, please?
Yes, thank you very much, and thank you very much for the lovely presentation. I'm a lecturer in management at Birkbeck College, University of London, and I'm an expert on employment relations. So my question relates to my work on collective bargaining and information consultation, and generally workers' participation. So one of the things that's concerns me is what happens especially in environments where trade unions are not as strong as in other sectors, for example, the economy, etc. And not only the UK, I have a European perspective as well. What role could trade unions play in this process? And I'm wondering whether the existing legislation on information consultation and all the rights that are provided to workers' representatives is enough eventually, or whether we need to make changes to adjust, let's say, the existing legal rights to better represent this new reality that we are faced with. Thank you very much.
Dee, shall I go first on this one? Yeah. I think the trade unions have an incredibly important role to play. And I do believe that in many circumstances, good employment practice can drive out bad, but it's not always the case. You just have to look at things like the discussion about the rag trade, what was happening with Boohoo, for instance, to know that this is not always the case. But I think there's a prior point. Trade unions can do nothing unless they understand the problem. And there are two aspects to this. One they can do something about, and another which it's much more difficult for them to engage with. What they can do about is to engage with this kind of discussion, the work of the TUC, the Institute of the Future of Work, and so on, in spreading knowledge amongst shop stewards and activists about how these problems exist and what laws are available to deal with them. But there's this prior point about observability, which is really worrying us, that an enormous amount is happening, which is simply not being seen, and which trade unions won't necessarily see either. And we think legislative intervention at this level is going to be important. We think it's going to have to be sector specific, although much of the discussion, for instance, within the European Commission, whose proposals in relation to this will come forward probably in April, is going to look at whether there have to be public declarations of high-risk uses of AI systems. So trade unions are part of the story, but they work in a way which is partly blindfolded, as do all of us, actually. And so they're not the end of the story, I'm afraid.
And just to add to that, we make various recommendations in our report about collective rights and how far duties around collective bargaining should be revisited. But something that we've often talked about is that many of these problems with AI and ADM will only be solved if there is a collective lens. And there are real parallels for us with equal pay. So, for example, it wasn't until the unions and other organisations became involved and said, you can't just look at what one woman's earning versus one man. You have to zoom in and see the collective, or zoom out and see the collective, and look at what lots of men are earning versus lots of women are earning. And it's only once you look at the problem through that prism that you start to see patterns and you start to see discrimination, you start to see cultural issues. We think the same will be true when it comes to AI and new technology. We think there will need to be a means of gathering data on how these new forms of technology are working so that we can see where the problem is. So we can see, for example, that an algorithm is stopping women seeing certain job adverts. So this is a two-way street when it comes to data. And I think that's the shift that we're hoping to encourage in the debate. The unions and other organisations really need to take this role of gathering data, taking the bigger picture, consolidating data so that they can understand precisely what's going on and then become really effective in terms of tackling problems in the workplace.
Absolutely. We make some really detailed recommendations, which we believe are completely novel in this area in the report. And we hope that you'll look at them and maybe take them forward in your next round of discussions.
Great, thank you. Thank you for the question and your responses. So the next question is from Camilla McLean, and it's concerning the chances of appropriate legislation being developed. Camilla, would you like to ask your question, please? Thank you.
Just trying to unmute myself there.
Thank you.
Thank you very much for the talk so far. It is really fascinating and not the least quite alarming, really. And so my question was, by the way, I'm an associate professor from Warwick Business School, and I've been trying to raise some of these issues with our students. And I frequently open my lecture in some of these areas with, do you care, that your personal data is being hoovered up and all the digital traces you're creating every time that you're online? And they all say, well, many of them say, no, I don't care because it's anonymous. And the other ones who do care say there's nothing we can do about it. So it sort of fits in very nicely with the aim of your discussion. But, there is a whole host of research and case studies out there indicating that our governments are not so inclined to restrict themselves in terms of creating the legislation, the necessary legislation. And I was even going to ask, in the UK, do workers even need to be told about being observed? What is the legality of this? And so if the governments themselves are implicated in the use of AI, ADM, and surveillance, the question is, do you think it's feasible, realistic that we're going to see legislation anytime soon? Plus, I think, sorry, I just was going to say, plus in the US, it was very clear in the when they invited up, Mark Zuckerberg to speak before Congress, that many of the congressmen and women had no idea about how the technology worked. So there was this huge knowledge gap, which impedes the lawmakers. Thank you.
Thanks, Camilla. I think what you've touched on is really fascinating, and something that Robin and I realized early on is that when it comes to thinking about AI and automated decision making, the problem tends to be viewed as a universal problem. So we tend to talk about all the different ways in which privacy is being infringed, or all the different ways in which there isn't observability and transparency. And on the one hand, that's very useful because you get a sense of the breadth of the problem. But that actually, we think going forward, we need to move away from the universal and start focusing on sectors, because each sector will have its own challenges. And I think taking more of a sectoral approach perhaps sidesteps the problem that you've identified, Camilla, of if you reform in one area, does it have implications for the other? And one of the reasons we were so excited about the TEC project was to be able to focus exclusively on the employment relationship. And I think a good illustration of this is the GDPR, or UK GDPR, as I have to keep calling it. And it's an important piece of legislation, but it impacts universally. And that creates problems because it means a lot of the concepts don't translate properly or well. And what we're very much in favour of is moving away from that and saying, where is there high risk and the employment relationship is clearly one such area. And then really thinking through the actual uses and the actual problems, with the hope that we then don't get bogged down in what's going on in different areas and different agendas. Robin, do you want to add anything to that?
I totally, well, I mean, you completely accurately represented our collective thinking on that. Just a sort of context point as well, Camilla. Don't be completely despairing about this. First of all, the Office for AI has suggested that legislation for regulation may be necessary, and that's a government body. Secondly, the Competition and Markets Authority at the present is involved in a consultation about the way in which markets are rigged by AI systems, which is quite likely to lead to some sort of regulatory intervention from them and may lead to legislation. The Care Quality Commission, we know, is looking at issues around this. And government got such a big wake-up call last summer over Ofqual and the algorithms over A-levels that, you know, algorithms don't solve every problem, and they certainly make some problems. That's for sure. Everybody recognizes that. And some of those problems make some politicians look really stupid. So, you know, I'm not completely despondent about this. I can, if I get round to it, put it in the chat either now or send an email to Digital Europe. But we are really in a very similar place to things that have happened in the past when new technologies have been introduced. Take the motor car, take television, whatever you like. Everybody thinks it's great. They start using it, ethical issues emerge, and then people start realizing you've got to have some regulation for it. So yes, of course, AI and ADM will be used in surveillance. It certainly is already. Just a word of warning to the wise, FRT is still pretty tricky in giving good, really good and reliable results. It's useful, but not the end. And there are other areas around that. So don't be completely despondent about it.
Great, thanks for that. Excuse me. I want to try and get through as many questions as possible. We've got 3 in the chat at the moment. So I'll ask the next 2 to ask their questions one after the other. And then if you could address both of them, Dee and Robin, please. So the first one is from Andrew Pakes about the impact of leaving the UK, leaving the European Union. And then the other one is from Jackie O'Reilly about companies auditing their own systems. So Andrew first and then Jackie, please.
Brilliant. Thank you, Dave. I'm from Prospect Union. This is one of our areas that we look at. Dee, Robin, I was reading this week the EU Commission's Social Pillars Plan, and the EU's always set out to be a world leader on technology, AI, and social responsibility and fundamental rights. And again, this week, it's talked about lots of the issues we've talked about today around the right to disconnect, always on culture, people in the loop, how it relates to privacy and social partners being involved in collective privacy as well as individual privacy. Have you got any reflections on, now we're outside of that, the risks of the UK being left behind, because we've always been a halfway house, even when we're in Europe, between the American model and the European model, or even potentially the opportunities that we could go at a faster speed because, you know, we're a smaller jurisdiction now to be able to make decisions?
Thank you. Jackie, do you want to ask your question, please, as well?
I'll try and ask it quite quickly. I wanted to ask and pull out a theme that's came out of an earlier talk with Simon Deakin about the relationship between, on one hand, legislation, collective bargaining, the legal profession, and how companies react to that. So what we've seen in the past is, for example, the rights of part-timers in 1986, the decision on Karen von Weber and Bilke Kaufhaus led a lot of companies to think, we don't want to go to the European Court of Justice, let's get our house in order. And more recently, you see companies being fully aware of this discrimination bias and trying to have things like fair aware calculators to audit their algorithms. There's the whole group at MIT who are working on this as well. So I just wondered what you thought, if while we're waiting for legislation to happen or collective bargaining to happen, what do you think about how companies are trying to audit themselves to effectively protect what they're doing? Robin, you're on mute.
Yeah,
Robin, you're on
sorry.
mute.
There we go.
Yeah.
Shall I take the first D and you take the second? Would you like to do that? Yeah. Thanks, Andrew. And thanks also for putting in the chat the link to the important work that Prospect have done with Telefonica on having time away, so the always on culture. It's an important link there for those that are interested in that particular aspect. But on the question that you ask, I think that there is one particular area which I would really push in relation to the UK, and it kind of connects in a way with the question from Jacqueline as well. We've been having discussions recently with the vice chair of the British Computer Society about the fact that data engineers, A, there are not enough of them in the UK, but B, their educational curriculum doesn't adequately deal with the kinds of issues that we're talking about at the moment. The ethics component is fairly thin. The legal component is almost non-existent. Now, this is really significant stuff because one of the things that is needed is to have good AI by design and to build a culture of good AI by design. Lots of people have talked about this, but the UK can do something about it. It has a very good university system. Many people here have a university base in this discussion, but really making those links between lawyers, data scientists, possibly ethicists, but those, and really getting to grips with what are the kind of red lines that there ought to be there and how they work together is something that we can definitely do. Otherwise, yes, I agree with you. We're sometimes feels as though we're in the middle of the Atlantic. We think that we will want to sometimes undermine European standards. That will be hopeless, but equally we will want to trade with America. Last point on this, it's a very short one, but if any of you are involved in international trade, please do watch out. International trade agreements are going to make this a difficult question about transparency and observability going forward as well. And we need to engage with that and set high standards of our politicians. Dee.
In terms of the second question, which was about auditing, yes, we think auditing is a really important idea. And it's interesting to see that one of the other questions that's been flagged in the chat from Rachel is how do you monitor inequality before the employment relationship has started? And it may well be that auditing is one solution to that. So looking for problems before they've arisen. And certainly something that we talk about in the TEC report is that auditing to date has been something that's very common in the data protection world because there's an obligation in certain circumstances to have data protection impact assessments. We think as a matter of law, those assessments should also be auditing the risk of discrimination. In our experience, that doesn't always happen. It seems that the equality world tends to be in one silo and the data protection world seems to be in another, and there isn't enough marrying up between the two of them. So auditing certainly part of the solution, but we don't think it's the complete solution because one, I think, disadvantage of auditing is it tends to be generic. And there will be certain circumstances where actually people need personalised explanations and understanding of how they're treated rather than sort of bigger picture trends. But certainly useful tool, should be encouraged. There should be more transparency around auditing and there should be stronger obligations around auditing.
Great, thank you, Dee. I was going to invite Rachel to ask the final question, but you've already dealt with that. I don't think there are any other outstanding questions that I can see. So that we do finish at 2 o'clock, as we said we would. I'd like to thank Dee and Robin once again for their really excellent presentation, so much to think about, and also, you know, to everybody for attending today and asking questions. You'll have seen, because it's come up on my screen, a short digit feedback poll. So it'd be really helpful if you could complete that. It doesn't take very long to do. Next week is the final debate in the spring series, when Ida Ponce del Castillo from the European Trade Union Institute will be examining algorithmic workplace surveillance. And that's been touched on obviously today. Gemma has posted up, or is going to post up, some links on how you can sign up to Digit news and events as well. So, as I say, just like to thank everybody again for their contributions, particularly obviously Robin and Dee. We are a couple of minutes early, but thank you to everybody and enjoy the rest of your day. Thank you.